I'm really happy to welcome you here. Bartosz Brozek is professor of law and professor of philosophy because he has 2 PhDs at the Jagiellonian University in Krakow. He's also a deputy director of the Copernicus Center for Interdisciplinary Studies. We've known each other for quite some time now. I haven't had time to read all the books he wrote because he wrote...
Me neither.
He wrote books on philosophy of law, philosophy of mathematics, cognitive sciences, and much more. Today he will speak about 2 phases of legal reasoning, and the floor is yours, Bartosz. Thank you.
Thank you very much for your kind invitation to this beautiful city and to this very nice university. I know you have a very strong group in legal philosophy, and this makes me a bit nervous before this presentation. I would like to talk about 2 phases of legal reasoning, and I would like to put forward a thesis, a claim that you cannot conceptualize legal reasoning as only rule-based or only case-based. Legal reasoning has 2 phases, but they are strictly interconnected. So you cannot have one without the other. And my claim is that this is for purely logical reasons, not something less. Okay, the outline. If I remember, the outline of the talk is the following. I will start with 2 thought experiments. We will first try to imagine a very simple, the simplest possible legal system, which is based on the top-down or rule-based scheme. And then another experiment would be about imagining a legal system which is based on the bottom-up approach, so it's only case-based. And I will try to show that in both cases we are logically forced to adopt at least an aspect of the other approach. So when we start with the top-down approach, we need to decide some cases which cannot be decided on the basis of the rules alone. And when we adopt the bottom-up approach, so start with the decided, settled legal cases, we need some abstract rules. Then I will try to establish some interim conclusions regarding those 2 thought experiments, and then I will try to persuade you that the actual legal systems, whether they prefer the top-down approach, like the continental or civil law systems, or the bottom-up approach, like in the case of the common law system, then actually they require this additional element from the other approach, and this will lead to the conclusion. What should I?
Just click here.
Okay, thank you. So let us start with the first thought experiment. This first thought experiment is connected with imagining the simplest possible legal system. It's a legal system in which we have only one legal norm. And let us assume, we can think of this norm in different ways, but let us assume that it is taken from Thomas Aquinas and it says, bonum est faciendum. Good should be done. And this is the only norm we have. It's quite an abstract norm that we have in our legal system. Now I have this formalization of this norm, which is a bit troublesome, and I will explain it in a minute. But let us assume right now that this is an acceptable formalization. And it says for every x, it ought to be the case that x does good, where x ranges over some agent or legal agent. The question now is how we decide, how we solve legal problems within the framework of such a simple legal system consisting of one abstract legal norm only. Of course, we need some definition or some elucidation of the very concept of a legal problem. And this is another simplification. Let us assume that any legal problem is represented by this, by a set consisting of two sentences. It ought to be the case that a certain concrete individual, designated with name, ought to do some action, or it is not the case that that person should or ought to do this action. Of course, this is a gross simplification. We can try to define a legal problem in a more complex way, but this is enough for our purposes. So, the task at hand to solve a legal problem within the context of our imagined legal system is to find a way, a deductive way, from the norm good should be done, or that every agent should do good, to the norm which says that a particular person should do action. If we cannot establish this, we should have a certain closure for our legal system which says if we cannot establish that that particular person designated by name should do action, we conclude that that person is not obligated to do that action. How to do that? Oh, the other way. In the standard deontic logic, and this is one thing we need to remember, there exists a rule which says if an implication N implies B holds, then it's also true that if it is obligatory that A, then it is obligatory that B. And now, in order to arrive from good should be done to the obligation of a particular person to do something, we need what I call a concretization rule. So it is a rule which says, for instance, for every X, if X does good, then X does action. And if we have this particular concretization rule, then it's quite easy to see with the use of the rule which is at the upper left hand, with the use of universal instantiation, with the use of modus ponens, that we can really arrive at the conclusion that a person designated with name should is obligated to do action. Now, what is the one problem here I would like to point out? The formalization of bonum est faciendum, good should be done, with for every X it is obligatory that X does good, is not the best logical rendering of this rule, because it is already personalized. Good should be done is not a norm that is personalized. So I would prefer to say that the best logical rendering of good should be done, bonum est faciendum, is to use propositional deontic logic, like here. So it ought to be the case that G, where G is a proposition describing that good is done. Yeah? The problem, of course, is that we want to move from this very general abstract norm, which is impersonal, to a norm prescribing that a concrete individual should do some concrete action. And this can be rendered in first order logic. There is a problem here, and I will come back to this later. Of course, we should rather not mix up those. It's not impossible, but I would prefer not to mix up those systems. But at this stage, I would like to draw your attention to the fact that on the one hand, if we think of a legal system which consists of one norm only saying bonum est patiendum, good should be done, the best way to render it logically is to use propositional logic. But when we go down and try to establish the obligations of particular individuals, it would be much better, it's necessary even, to use first order logic, because only in this way we can say that this individual should or ought to do this or that. As I said, I will come back to this point a bit later, but now the main part of this whole experiment. If we think of a legal system which consists of one norm only, good should be done, then my claim is that this norm describes a certain deontically perfect state of affairs, a set of deontically perfect words. And the claim is that there are many mutually exclusive ways to realize the same deontically perfect state of affairs. Imagine that we have the norm saying that the environment should be protected. And imagine that one of the way that we established that one of the way of protecting the environment is not to use or be careful while using plastic bottles. So the protection of an environment regarding the use of plastic can be realized at least in two different ways. One way is to have the obligation put on the citizens to recycle plastic bottles. Another one is to say they cannot be produced anymore. We don't produce them. We obtain more or less the same outcome, provided that people really do follow those two norms. So we imagine a deontically perfect world in which environment is protected because plastic is used or not used at all, or does not cause problems to the environment, but we can realize it in different ways. I believe that this point may be generalized with the use of a very simple distinction regarding obligations. When we think of obligations, we can have individual obligations, which is an obligation put on an individual person, or we can have group obligations, so obligations which pertain to a number of people. For instance, I have at least a moral obligation to deliver a lecture here, and you have at least a moral obligation as a group to listen to this talk. Group obligations come in two different forms. We can speak of group obligations proper and group obligations improper. A proper group obligation is an obligation which may be fulfilled by the group only when all the members of the group do something. For instance, if we have a class and there is the rule saying that during the class students should stay silent as a group. This obligation will be fulfilled only when all of them stay silent. But we can have another obligation saying that before the class begins, the student should prepare the blackboard or the overhead. The students should prepare the blackboard or the overhead projector or something like that. And it's enough that one of them does this, and the obligation is fulfilled. So this is I think, quite an obvious distinction. And now the claim here is that the obligation expressed by bonum est patiendum, this one abstract norm, good should be done, is an improper group obligation. And if it is an improper group obligation, so we all, as the addressees of the law, should do good. But if it is an improper group obligation, this very general rule can be concretized in very different ways, because there are different ways to achieve the same goal. So we, as a group, we will do good if we recycle the plastic bottles, but at the same time, we can achieve the same goal, do good, when we stop producing them, and so on and so on. Okay. So, the conclusions from the first thought experiment would be that the abstract duty to do good is multiply realizable, which means that there is always more than one way to find oneself in one of the deontically perfect worlds. It follows that a normative system of purely abstract rules is never self-sufficient. It cannot constitute the sole basis for arriving at every particular duty of every particular person, because there is no one procedure giving a unique result of transforming this general and abstract rule into concrete obligations because of the multiple realizability of improper good. And please notice that this is for purely logical reasons. This is not something which, for instance, is connected with the vagueness or the open texture of legal language, because you can think about the situation in the following way. Doing good is a vague concept. The more abstract the rules, the more abstract rules we have in our legal system, the more higher are they on the level of abstractness and generality, the more vague they become. And when they are vague, there is the core of determinacy. So sometimes we know what good means, what doing good means, but there is also the penumbra of indeterminacy. So we are not sure whether this action or that action is good or not. This has nothing to do with my argument here. We can assume that the language we use is not vague, it's completely precise, and nevertheless we will get the same result. Also, it has nothing to do with the open texture of language. I understand open texture as the feature of language which, even if the concepts we use are not vague, are precise right now, that they may become vague when the social reality changes. So for instance, the concept of legal agency may be quite precise now, but in the future, when there will be autonomous intelligent robots, we may have to rethink what legal agency is, because the very concept will become vague in face of the technological developments. Okay, now let us move to the second thought experiment. And right now I would like you to imagine a completely different legal system. A legal system in which we have only settled cases decided before by some court. What does it mean? It means that we have only the descriptions of those cases, and we have the information of what is the obligation of a particular person. We have no abstract rule. We have no rule of behavior whatsoever. So, for instance, let us assume that in our system there are 4 different cases previously decided by the court. The first case pertains to a person A, and the person A is someone who sells goods, is a foreigner, is a resident in the given country, and sells alcohol. And the only normative statement in the description of this case is that A ought to pay taxes. Now, the second person, B, sells goods, is not a foreigner, is a resident, sells alcohol, and B also has to pay taxes. C, the person C in case 3, doesn't sell goods, is not a foreigner, is a resident, does not sell alcohol, and does not have to pay taxes. And finally, the person D sells goods, is a foreigner, is not a resident, does not sell alcohol, and does not have to pay taxes. This is everything we have. Of course, we have 4 cases here, but I assume that we can have many, many more such cases. The argument would be exactly the same. And let us imagine now that we have a new case, the fifth case, and we are the judges. And what we know is that the fifth person, E, sells goods, is a foreigner, is a resident, and does not sell alcohol. And the question we need to determine, having no rules whatsoever, is whether E pays taxes, or ought to pay taxes, or does not have to pay taxes. How to do it? How to do it in a rational way? Of course, I would assume that it is impossible to do it in a rational way without invoking some rule of behavior. Because otherwise this decision may be just the flip of the coin. So we need some justification, so we need some rule. Okay, an easy idea of how to do it is to try to extract the rules which are somehow embodied in the previously decided cases. This is basically the idea behind the common law system. Is it possible to do it? The problem is that cases 1 to 4, the previously decided cases, are compatible with different abstract rules. Not only the 3 enumerated here, but possibly many more. So they are compatible with the rule saying whoever sells goods and is a resident ought to pay the tax. It is compatible with the rule saying whoever sells alcohol ought to pay tax. And it is compatible with the rule whoever sells goods and is not the person D, so one particular person, who apparently enjoys a personal exemption from paying taxes, ought to pay tax. I don't know, should I come back to this slide to check whether this is right, or you see it? You see it. Okay. So there are different ways of extracting the rules of behavior on the basis of the existing and already decided cases. And this is a problem for our new case, the case number 5. Because if we reconstruct the logic behind the decisions in cases 1 to 4 as R1 or R3, this would lead to the conclusion that the person E, in the new case, should pay the tax. But if our decision is to reconstruct the logic behind the 4 previously decided cases as involving the rule number 2, the outcome will be that the person E, the person in the new 5th case, does not have to pay taxes. Yeah? This also can be generalized along the lines of Quine's underdetermination thesis. You remember Quine saying that any theory is underdetermined by past evidence. A future observation can conflict with it. Naturally, it is underdetermined by past and future evidence combined, since some observable event that conflicts with it can happen to go unobserved. Moreover, many people will agree, far beyond all this, that physical theory is underdetermined even by all possible observations. So the famous, the famous claim of Quine pertaining to physical theory is: no matter how many observations you have, you will always be able to explain those observations with alternative and competing theories. And I believe that the same applies to our second thought experiment. No number of past and future individual legal decisions, as well as all possible decisions, determines a unique set of rules of behavior. There is no legal system without abstract and universal rules, in addition to the descriptions of the cases we have. So no matter how many cases are described, we can still reconstruct the rules behind them in different ways. So we need to make a decision which is not inscribed in the cases themselves, which of the set of rules to choose. So my interim conclusion is that legal thinking cannot dispense with neither abstract rules nor individual cases. It is a constant interplay between the abstract and the concrete. In any legal system, whether it's mainly case-based or rule-based, decisions must be made which do not follow logically from the system itself. They are not encapsulated in the system itself. They are, in a sense, extra-systemic. Importantly, the reasons behind this fact are purely logical. Abstract legal rules do not fully determine all particular obligations, while any finite set of particular cases is compatible with many different systems of abstract rules. Now, another aspect of the conclusions here, something which I believe was not included in the paper, I think Andrei distributed, and which I would like to connect with the problem I had at the very beginning of how to render formally the norm "good should be done, bonum est faciendum." Because, as I said, I prefer to do it with the propositional logic, but then when we arrive at a particular obligation of a particular person, it was much better, or the only possibility was to use the first order deontic logic. So I think that there is a philosophical difference between the two approaches, the top-down approach to obligation, to legal obligation, and the bottom-up approach. If we think of obligations in general, not only legal obligations, we can distinguish different kinds of obligations. For instance, we can distinguish between unconditional and conditional obligations. Unconditional obligations are those which are binding under any circumstances. Conditional obligations are those obligations which have certain conditions of application. So, if you are a public official, this is the condition, then you should do this or that. Good should be done, as we remember, is unconditional. No matter who you are, no matter what you do, you should do good. So this is the first distinction. The second is between categorical and hypothetical obligations. Categorical obligations are those which we are obliged to fulfill, which we have to fulfill, irrespective of some external normative considerations. And hypothetical obligations are those which are triggered by some external normative considerations. For instance, if you think of David Hume's analysis, so let us contrast two things. Kant's analysis of morals and Hume's analysis of morals. According to Kant, you should follow a moral rule out of duty, because this is a moral rule. So it's a categorical obligation. According to Hume, we have a certain system of moral norms or moral rules which emerge on the basis of our sentiments, and you know the story. But he also says we are obliged to follow them because of what he calls the reflective endorsement. So we use our reason and we use our self-interest to say that, okay, this system of moral rules, which emerge irrespective of our reasoned decisions, is in fact good for us. So this is an external normative consideration which says we should follow the system of moral rules in the given society. So this is the distinction between categorical and hypothetical obligations. Then we have much easier distinctions, at least from the point of view of explaining them. So we can distinguish between impersonal and personal obligation. An impersonal obligation is an obligation which is not put on a particular person, like good should be done, environment should be protected, and so on and so on. A personal obligation is an obligation of a concrete person to do a concrete thing. We can distinguish between all things considered and prima facie obligations. All things considered, obligations cannot be defeated by some other obligation, because they are all things considered. Prima facie obligations may be defeated by some stronger obligation. And there is also in the philosophical literature this famous distinction between ought to be and ought to do. This is a tricky distinction, and there is huge literature on the subject. But to put it simply, ought to be is an obligation which says that some state of affairs should be obtained, and ought to do is an obligation which says that someone should perform some action. Something should be done, and not a state of affairs obtained. And my impression is, and I think it's a bit more than an impression, that those kinds of obligations form the two groups. The first group, and this is a natural way of thinking about the top-down approach, is that we have unconditional, categorical, impersonal, all things considered, and ought to be obligations. And on the other hand, the second group, the natural group, is obligations which are constructed as conditional, hypothetical, personal, prima facie, and ought to do, and they are characteristic of the bottom-up approach. When we start with analyzing obligations of particular persons, so we need them to be conditional, we need them to be hypothetical, we need them to be personal, prima facie, and ought to do. And this is, I believe, something which is this dual character of obligation is a reflection of the two approaches to thinking about not only legal system but any normative system, top-down and bottom-up. So this is another illustration that something, there is a thing going here which shows that there is some incompatibility between the two approaches, but none of those approaches is sufficient on its own. Okay, and let us please say hello to Robert. He is, of course, the famous German legal philosopher. This is recorded, so there are things I cannot say. I'm sorry, but maybe during lunch, if there is lunch. Robert is famous for, maybe not for introducing, but for making explicit the distinction between two types of legal norms, legal rules and legal principles. According to Alexei, rules are norms which are always either fulfilled or not, you remember that, and principles are optimization requirements. So a legal system, according to Alexei, I know that there are many other definitions of legal rules and principles, and I personally believe that this is all nonsense, the distinction between rules and principles, but this is not the object of this, the subject of this talk. So if we think of a legal system, and this is looking at things from the continental perspective, from the perspective of the most typical civil law system, which is the German legal system. So amongst legal norms, we have two types of norms: rules and principles. Rules are, I believe, much closer to what we call the bottom-up approach, really. So they establish obligations of particular classes of agents to do particular kinds of things. But there are also principles which Alexei deems the optimization requirements. They are quite impersonal. These are things like the environment should be protected by the law. Why do we need them? Why do we need them? We need them because of this way of the top-down way of thinking. We would like to, we imagine a deontically perfect world, or a set of deontically perfect worlds. We put some system of rules which enable us to get to this deontically, to one of the deontically perfect worlds, but this is not enough. We need something more to secure that this indeed can be done. And for this we need principles. And as you may well remember, Alexei claims that there may occur conflicts between two legal principles, or a legal rule and a legal principle. And they are decided with a very strange thing which is called the weight formula. But we can imagine that it is decided in a different way. For instance, with the use of the economic analysis of law. If we say that principles are optimization requirements, then economics and optimization go hand in hand. And, well, because of that, we can replace the weight formula with something else. The point is that Alexei's analysis shows that an exclusively rule-based reasoning is impossible. Why? Because there always will be situations when there is a conflict between two norms, two principles, a rule and a principle, and so on and so on. And they are decided by something which is extra-systemic. The weight formula is not inscribed into the German legal system in any way, or the economic analysis of law is not to be found there. This is not logic. This is, Alexei claims this is arithmetics. Well, it is, but it has little to do with deciding real legal cases. The important thing here is that this decision is always, and this is an important intuition Alexei brings to the fore, that this decision is always case-related. So when we have a conflict between two principles, on a rule and a principle, we make a decision according to weight formula or something else, but this decision is case-related. So this is an individual decision in an individual case. This is not something that can be easily repeated in similar cases, because the balancing process may lead to a different outcome. So this shows that even if we imagine a legal system as consisting of rules and principles, there still is, so this is the top-down approach, really. There still is a place where we will need to supply this system with a decision in a concrete case, which does not follow from neither rules nor principles, but from something external, which Alexei calls the weight formula. Of course, he would disagree with this and said, no, this decision is based on the law. It is based on a principle, which prevails in the comparison with other principles. But this is just a kind of mambo-jumbo. It does not follow from the principle, and does not follow from the rule. It's decided by something external to the legal system. Maybe not to the legal tradition, but to the legal system understood as a system of norms, be they rules or principles. Okay, and now let us think a bit about case-based reasoning. In order to do it, it's always good to start with a particular case. And the particular case in this instance is the famous case Donahue versus Stevenson. This is a very traumatic case. It was, at least for Miss Donahue. She went to a cafe with a friend. The friend brought her a bottle of ginger beer and an ice cream. The ginger beer came in an opaque bottle so that the contents could not be seen. Mrs. Donahue poured half the contents of the bottle over her ice cream and also drank some from the bottle. After eating part of the ice cream, she then poured the remaining contents of the bottle over the ice cream, and a decomposed snail emerged from the bottle. Mrs. Donahue suffered personal injury as a result. She commenced a claim against the manufacturer of the ginger beer. The case went to the House of Lords, and she won. The House of Lords said that the manufacturer of the ginger beer, Stevenson, should pay the damages to Mrs. Stevenson.
Mrs. Donahue.
What did I say?
Stevenson.
Donahue, of course. Thank you. So that was the decision in this case. But if we look at the facts of the case and the decision made by the House of Lords, without invoking any rule, we can think of various rules which might have been the basis for the decision of the House of Lords. Like, a manufacturer is always liable for such occurrences, or a manufacturer is liable only when a reasonable customer is not informed or cannot easily foresee the danger associated with using the product. Or, a manufacturer is liable only when the particular customer is not informed about, Mrs. Donahue in this case, is not informed about the danger associated with using the product. Or, a manufacturer is liable unless everyone knows about the danger associated with using the product, and so on and so on. So we can think of the rules governing the decision of the House of Lords in quite different ways. But then the common law system has different mechanisms which help the system to evolve. One of them is distinguishing. And you know what distinguishing is. The famous distinguishing in the context of Donahue versus Stevenson was the case McTeer versus Imperial Tobacco. It was a case about Mr. McTeer, who died of lung cancer. He was smoking a lot of the products manufactured by Imperial Tobacco. And I believe that the daughter of Mr. McTeer sued Imperial Tobacco, citing, amongst others, the Donahue versus Stevenson. There is a product manufactured by someone else is using this product, suffered, so I, as a daughter, want the money from you, Imperial Tobacco. And the decision in this case was, no, there is no grounds for any claim here, because unlike in the case of Donahue versus Stevenson, Mr. McTeer knew that the product he was using, the tobacco, might have led to the lung cancer. In the case of Donahue versus Stevenson, Mrs. Donahue had no grounds for expecting that the decomposing snail will emerge from the bottle. This is not the typical thing when we think of ginger beer and the bottles of ginger beer. But with tobacco, well, we know all the substances there and what they may cause. So in a way, by distinguishing McTeer versus Imperial Tobacco, the court excluded rules R1, R2, and R4, R3, so it should be R1, R3, and R4, and retained only rule R1 as the basis for the decision in Donahue versus Stevenson. So that's how it works, and you can observe that it's quite similar to what we did in our second thought experiment. Okay, so the conclusions. The conclusions are that it is impossible in the general case to arrive at a legal decision by purely abstract or purely concrete reasoning. This is so for purely logical reasons, and this is illustrated with the actual practice as well as theory behind the common law and civil law systems. Rule-based and case-based approaches may be two different sides of legal reasoning, but they are sides of the same coin. In other words, you can't have one without the other. Thank you kindly.